Additional issues that exist in a divorce case are the division of property, division of debt, spousal maintenance, and changing of the name for the wife. There are two types of property the parties or the court may have to divide in a divorce case. First, there is the party's real property, which is the party's house or any other land or real estate that they own. Second, there is the party's personal property, which is their cars, boats, and household furnishings, such as furniture and appliances. Personal property may also include items such as jewelry, clothing, bank accounts, and retirement accounts. Please know that the court only divides community property and does not divide separate property. Community property is property that the parties acquired during their marriage. Community property does not include property that you acquired by gift or inheritance, even if you got that gift or inheritance while you were married. Also, any property you acquired after the petition for dissolution was served is not considered community property. Under Arizona law, the community ends on the date the petition for dissolution is served. Arizona law also says that the court must divide community property equitably without regard to marital misconduct. That means that as far as dollar amounts go, both the husband and the wife will receive pretty much the same amount of the community property. Under Arizona law, separate property is the property that is owned by husband or wife before the marriage, bought by husband or wife with separate funds, such as funds from an inheritance or gift, or bought by husband or wife after the petition for dissolution was served. Under Arizona law, a husband gets to keep any property that is his separate property, and a wife gets to keep any property that is her separate property. In addition to dividing the parties' community property, the court also will divide the parties' community debt, such as mortgage, credit card debt, a car loan, student loans, other types of loans, and taxes. Just like community property, community debt is divided equitably, without regard to marital misconduct, so each party will end up with about the same amount of that debt. For example, if you have $5,000 in community debt, each side will probably be ordered to pay about $2,500 of that debt. If any of the debt was acquired before the marriage, that debt will probably be treated as sole and separate debt and will have to be paid by whichever party incurred that debt. So if prior to the marriage you still owed $2,000 in student loans, you will be solely responsible for that student loan debt. It will not be considered a community debt. If you or the other side acquired credit cards during the marriage, the court will probably treat any amounts owed on those credit cards as a community debt, even if the credit cards are only in one party's name. The court may also have to decide whether a party gets spousal maintenance, which, in essence, is what people used to call alimony. To qualify for spousal maintenance, the court has to find that the party asking for spousal maintenance meets one of the following criteria. The party does not have enough property, including any property that party receives in the divorce, to provide for the party's reasonable needs. Or, the party is not able to obtain a job that will pay enough to live on, or the party is not able to work outside the home for reasons such as being disabled or has to stay home to take care of a special needs child. Or the party asking for spousal maintenance helped the other side get through school or get ahead in their career. If the court finds one of these factors, the court may order spousal maintenance and will determine the amount of spousal maintenance and how long it will be paid. Lastly, the court may be asked to rule on a request made by the wife to change her name back to her maiden name. Typically, the court will grant these requests and will include the name change in the dissolution decree.